My lord, the petitioner is president of Committee for Legal Aid to Poor, working on the ground grassroots level on the issue of access to justice and child rights.
You wanted the fair shop
My lord,
in the near. Yes, who is for the other side? Yes, that is at the doorstep. You should be given a fair price shop. What affidavit? Affidavit within 2 weeks, rejoinder within 1 week after the vacation. Okay. Give a date. Number 2.
Appearing for the petitioner in this case, your officers.
Yes.
May I please, madam? My lord, offense alleged against me are all IPC offenses.
Which one you want to declare as?
My
What
lord,
is this prayer? What is, I do not know why annexure 1 shall not be declared virus to the constitution. Virus means
Ultra.
either ultra virus or intra virus.
You should have preceded with the word ultra. My lord, I am charged with offenses under IPC. None of the OPID sections, charging sections are there as against me. The Lordship must kindly look at.
What is this? This is the 4th number of the special court they wanted to establish. Then what is the difficulty?
Difficulty, my lord. I am charged with sections. Your Lordship may kindly look at the next page, page 16. 419, 420, 467, 468, 471, 120B.
True.
These are magistrate tribal offences.
True.
But if this goes to my lord, I am not charged under OPID in any case.
Okay.
So now if it is tried under the OPID Act, which is the district, almost a district judge cadre, my lord.
Have they sent it?
Yes, it is there.
Where?
Before the OPID cut Cuttack. Your Lordship may look at the notification at page 2.
Yes, I am looking at it. That's why I am saying it is under 4th number of the special cause under the Odisha Protection of Depositors and as a special court. So this is really an economic offense.
In not that sense of the term, my lord. Let me place, my lord, the
What is the
essence of the
420 when it is introduced? What is this offense?
cheating someone, my lord. 420.
In a economic offense is there.
Your Lordship may kindly proceed, my lord, will agree with me. My lord, it starts with the act starts with the section 1, my lord. This act may be called the Odisha Protection of Interest of Depositors in Financial Establishment.
You're reading that.
OPID Act,
Yes.
my lord. This act may be called the Odisha OPID Act. That's normally we call it OPID Act. It extends to whole of state of Odisha. And then, my lord, what deposit is related to deposits? This entire act comes as a deposits is there. Deposit includes and shall be deemed always to have included any receipt of money or acceptance of any valuable commodity to be returned after a specified period or otherwise, either in cash or in kind, in form of a specified service by a financial establishment, with or without any benefit in from the
What
interest.
company you floated? It's like a Ponzi affairs. I could understand. It's like a Ponzi affairs.
Yes,
What company you have floated?
No company, my lord. I'm an individual. allegation against me, certain properties has been sold to someone by an individual where I am not a party. There they say I have persuaded that person to impersonate and go in with the sale proceeds. So,
Does it belong to any company?
no, my lord, private property. The lordship may
Why
kindly
your affidavit show us that how it can? But it can't be because it has gone there, you just show me. Whether this matter has gone there. 2 week, 1 week thereafter, after vacation.
Yes, ma'am.
And the matter will give a date.
13th January. Item number 3, 13th January.
This is a public interpretation file highlighting the suffering of the people of the state because of the frequent strikes by these government employees. Yes, because of the frequent strikes by these government employees in the state of Orissa. The matters the Orissa government service control since 1959 at page 13 matters. It completely prohibits any kind of strike by the government employees.
Definitely.
Yes, my lords. So the government is not taking any action in these.
The strike has been declared as illegal. That is Supreme Court also.
But this one,
Sorry, Your Worship.
Yes. I'm taking it off the list. Let's take instructions.
This is related to the
Supreme Court has also in the many judgments, even from Kerala, that goes and saying that the strike is absolutely illegal.
even by this honorable court reports.
You can't do. How can you permit them to continue and strike? The trade union movement, what?
Actually, this is relating to one incident.
I'm asking you, is a trade union movement or what? It's not a trade union movement. Then how can you do strike?
Given two examples for others. But this is a frequent strikes by this. Now, this primary school teacher also on strike for the last 2 or 3 days, 22 to 27. The entire
And
system
who
is
the
paralyzed.
biggest sufferer is the children. The appeal is that there is knocking the door. You can't do that. Have you made any union or something with the?
Yes, madam. The Odisha Administrative Service Association and the Odisha.
Serve a notice, issue a notice, you tell them after 2 weeks, you can give a police.
Item number 4.
And come with those line of judgments on the other day.
Yes, madam.
Okay.
Item number 4, Millard. I am for the villagers, Millard. Millard, the petitioners are villagers of village Apartibindha, Millard. The village Apartibindha situates inside Bhadrak town. It situates at the south side of river Salandi. Salandi river flown inside Bhadrak town, Millard. And in every year, due to flood in river Salandi, the river is changing its belt and its water channels. Millard, and the adjacent landowners taking advantage of changing of belt of the river, they are encroaching the land and are river land and are constructing residential building on it, Millard. In this connection, the petitioners, villagers, given their representation to opposite part number 1 to 7, Millard. Annexure 1, their representation. And after entertaining their representation, the opposite part number 3 given direction to opposite part number 5 to cause an inquiry. And the inquiry was conducted by opposite part number 5. Millard, your lordship may kindly have a glance. Just I am showing certain relevant portions of inquiry report. That is page 22, annexure 4, Millard. Suitable measures which can be taken.
Yes.
Okay, but
Four measures were suggested.
yes, Millard. And in this connection, The opposite part number 3 given direction by his letter given direction to opposite part number 4 to conduct an inquiry. No, to implement it. To implement it through annexure 5, page 23.
No, that is simply forwarding of the copy.
Yes, Miller. Till
That's the
that
forwarding of the copy.
copy, Miller. Till that it has not been implemented, Miller.
What is this, madam?
Matter that preliminary assessment has been done, Magnus, and thereafter, with the cooperation of all the government officials, this process will be completed in 3 months' time. That is within our administration.
My lord, my humble submission before your
Just 1 minute, just 1 minute.
Miller.
No, this is what an eviction.
Yes,
But there is already a suggestion which has been given that in order to have any kind of a erosion on the river bed, they wanted that there should be some guideline, something which has to be done. Identify that this is the river bed, and thereafter the plantation has to be done so that there is no further erosion of this, and then something is to be taken uh, under the development process so that at least suitable things can be done, because you are also disposing of the garbage that is not permissible. And then in order to avoid any kind of a flood, then you'll have to take.
which it's
But you are talking about only the eviction of the encroachers.
primarily, this is what I could gather, my lords, because due to encroachment, a lot of things could not be done, my lord. This is the first requirement which is to be required to be done. And then- That is it.
On the basis of this,
Accepted the inquiry report.
Primarily, this is what is on record, my lord.
Yes.
Thereafter, this is
But there should be a full-fledged committee to be constituted who will just undergo the entire thing, because the inquiry report is not that sacrosanct that it is everything is to be done. There may be something more which can be done. So all these things, then you will have to undertake exercise. There should be a specialized committee for that to overview the entire situations. You can remove the encroachers, but the problem is something else.
because main problem is the flood zone that
True.
needs to be protected.
So what steps you want to take?
But I'll take further instructions in this matter, my lords. Were there any other step for erosion of or flood zone protection has been taken or not, my lords?
देखो
No, in this case, the notification issued at page 49, empowering the Tahsildar,
Legit.
introducing a provision under Rule 34G to adjudicate the matter regarding the legality of
So Odisha Survey and Settlement Act and the rules. Yes.
legality of transfer effected prior to the finalization of the record of right, whether prepared under the Odisha Survey Settlement or Consolidation Act, is now given to the Tahsildar. Clear? There are two different statutes we have. Survey Settlement Act is for preparation of the record of right, and that adjudication made by the under that statute we have. Under Rule 33, the power of Tahsildar for maintenance of record of right was specifically taken out. So
And given to whom?
no, to the settlement. To the settlement.
Settlement officer.
Settlement officer or assistant settlement officer.
Who is a settlement and what is his designation?
Settlement officer and assistant settlement officer are described under the Odisha Survey Settlement Act.
Who are they?
Officer specially designated for the purpose of.
So it can be designated to anybody. It does not say. It is only the notification conferring power to act as a settlement officer.
Section 33 is during the pendency of the survey settlement operation. It specifically taken away the power of Tahsildar for maintenance of record of right. Rule 34 empowers the Tahsildar to effect any changes made after the final publication of record of right, whether by way of transfer, by way of death, or by any decree of the court.
Correct.
That was the rule. Now in the Rule 34G, they introduced that the Tahsildar is empowered to adjudicate regarding the flow of title and to make necessary correction of the record of right, whether prepared by the under the Survey Settlement Act or Consolidation Act.
So,
Miller, there the Lordship will see under the Consolidation Act, Miller.
as you said, that this Tahsildar under Rule 34 has already been empowered to alter or affect any changes in the record of rights necessitated by a transfer or by an order of the court. So Tahsildar has a power to make a changes.
Only changes to give effect to the order passed by the
No, you say the transfer also.
transfer effected after the record of right was finally prepared.
So this has already been finally published.
Here they say that even he can go to the extent of legality of transfer, that is prior to the publication of the record. That is, that means any adjudication made by the statutory authority under the Survey Settlement Act or Consolidation Officer under the Consolidation Act, it has got no binding effect on the Tahsildar. He can go travel back to adjudication the legality of transfer, direct of the recording of the made after in the final publication of record. So that means the adjudication made under the Act are now made negative.
No. Just show me the Odisha settlement.
Miller.
Odisha Survey and Settlement.
Miller, before kindly see Survey Settlement Act, also kindly turn to
1962. This is 1952. No, this
58 Act, 62 rules.
Yes.
Act of the year 1958.
Just one. Yes, yes.
Now, Mr. Lordsman, kindly see the section 4
Of
the Orissa Consolidation. CH and PFL Act 1972.
1972.
And Prevention of Harmony.
1972,
Miller. This is a section 4.
4.
Miller.
Yes.
Kindly see subsection 3 and subsection 4. Every proceeding relating to survey, preparation and maintenance of record of right and settlement of rent shall stand abated after publication of the notification under subsection 1 of section 6, and every suit and proceeding or declaration of a right or interest in any land situated within the consultation area in regard to which the proceeding could be or ought to be started under this act, which is pending before any civil court, whether of the first instance or appeal, reference or revision, shall on an order being passed in that behalf by the court before which such suit or proceeding is pending stand abated. Then your lordship may kindly turn to section 9 there. Section 9, subsection 3. Section 9, subsection 1 is preparation of the copy of the map and land register, Miller. So the section 9(3) NB says, Miller, that any person to whom a notice under subsection 2 has been sent or any other person interested may within 30 days of the receipt of the notice or the publication under subsection 1, as the case may be, file before the assistant consultation officer objection on the correctness of the entries in the records and the extracts furnished therefrom, or on the statement of principle or relating to partition. Then you also may kindly turn to section 10. Under section 10, such objection means refer to 9(3). Then 1(b). Such objection relating to right, title, and interest in land as can, in the conformity with the laws in force, be disposed of by conciliation amongst the parties concerned, shall be disposed of by the assistant consultation officer, provided not all subsection 2, Miller, all objection which cannot be
So
disposed of by
this is really a process of conciliation.
Miller,
Conciliation means by an agreement of the parties.
absolutely correct.
It is not an adjudication in that sense.
There is subsection 2, Miller.
I have seen all objection which cannot be disposed of by the conciliating under this one.
Shall be
Another objection that shall be settled, shall be forwarded to a assistant consolidated officer.
to the consultation officer.
Sir, assistant consolidation officer
Miller.
to the consolidation officer.
Any objection which cannot be adjudicated by conciliation, it will be referred to consolidation officer for adjudication. Then your lordship may kindly see section 11. So that is adjudication of right title interest by the consolidation officer. The consolidation officer shall dispose of objection forwarded to him under subsection 2 of the section 10 after giving the parties concerned a reasonable opportunity of being heard and after such local inspection as he deems necessary, provided that in disposing of objection.
No, that I have seen that he will hear out the objection for disposing of. He will consult also the Gram Panchayat.
Miller. Now, this adjudication made by the consolidation officer can be challenged in appeal.
Appeal, that is, I have seen section 12.
So, any person who is aggrieved against the operator.
But there is also a provision of a revision under section
36.
13.
Miller, 36.
13 also. Come.
Miller.
13 of the Act.
That 13 is different. Miller.
No, what different?
Miller.
The map, the land register and other records,
Miller.
it says, if any, prepared under section 6 shall be revised, if necessary on the basis of an order passed under section 10, 11, 12 and shall be published for a period of 15 days.
Miller. That is
correct.
That is for preparation of the scheme. But this order under section 12 is revisable under section 36, my lord, before the commission.
Yes.
That your lordship may kindly see section 36 empowers the commissioner to adjudicate any order passed by in appeal under section 12.
Yes.
No, it says, my lord, that this order of the commissioner will be final.
Yes.
Miller, that the commissioner under section 36 has got the power to adjudicate or insert the adjudication made by the subordinate officer like the CO and deputy director under section 10 or 11,
Yes.
Miller, 12. Now the question is, Miller, here at the same time, suppose your lordship has seen section 9.2 that suppose somebody within 30 days could not file objection because the authority are deciding the right title interest, my lord, the jurisdiction of civil court is taken away. Under section 37, they can directly approach either the director or the commission. The lordship can see 37. So, there's the statute provide a complete scheme for adjudication of right title interest.
9.2, I do not find the 9.2 of the Consolidation Act 72. It simply talks of the notices containing relevant extracts from the land register showing the rights and liabilities of the landowner.
Absolutely correct.
In relation to a land, specific shares of the individual landowners in a joint holding when necessary to ensure proper consolidation, valuation of lands and the valuation of houses, structures, such and such, calculating the compensation therefore and its appointment under the landowners. If there is more than one landowner, then one shall be sent to the landowner mentioned in the land register.
Right.
So this is what a maintenance of a land records where after this consolidation, what is this consolidation? Purpose of the consolidation?
In nutshell, I am explaining to you, Lordship, my lord. So, because consolidation means two things, my lord.
Two different things have to be amalgamated or merged into one. That's the consolidation.
That is one aspect.
Yeah.
That is one aspect. Because under the consolidation.
That is a common meaning.
That is
contiguous smaller patches are in exchange of larger patches.
That is the aim. So that under the Consolidation Act, only a landholder can be provided with 3 rectangular process carved out chokos.
Right.
I know, to avoid, not only to avoid fragmentation, but to encourage consolidation. I'm quite conscious in every state, the act has come
Right.
for this purpose, because it's an agrarian reforms. If it is a large number of a tract of our land, it would make more yield than a smaller fragmented manner.
That was the amendment.
Oh, I understand. That is what I am conscious of, those positions. Here, that's a very unique thing that you say. Suppose a person has land, agricultural land at a place A. Let us see, place A, which is under the different Gram Panchayat.
Right.
And he has a smaller land, very small, negligible land at B, which is another Gram Panchayat.
Right.
Does it mean that this B land
Is to be shifted to
is shifted to A to make it, and then the owner of this A, the owner of the adjoining land, because the land it cannot expand, nor you can abridge. The land would remain a land.
Right.
So somebody has to be displaced from his property.
Absolutely correct.
So that to accommodate A with his property at B,
To be shifted to his
correct, to merge or consolidate with A, then the property owned by some other person, say of a same demand, the measurement or a same land, what would happen to his property?
He is to be given in other area.
So it is a complete exercise. Suppose he does not have any land anywhere. And you visualize, he does not own any land anywhere. It's the only land which is there.
Then he cannot be shifted. That was
that is what I just wanted to understand. So it cannot be shifted. You can't displace a rightful owner. Right to property is a constitutional right. Article 300 capitally. It is a constitutional right.
Absolutely.
So you can't take up it without the process of law.
Right.
So if it cannot be adjusted, then there cannot be any consolidation.
Right. No, but there can be. Well, your lordship is talking about a single instance. But here the legislature has provided under the statute, a person can be given 3 rectangular process of land, 3 parcels of land. It may be consisting of any area. So at best, a person, a landholder can apply his choice that he will take 3 parcels of agricultural land. Which is
how? Then what is the purpose of consolidation?
The purpose of consolidation means, if he has suppose 10 separate patches of land scattered at different villages, he can be accommodated in maximum 3.
I understand, sir. But the situation is when it has only 2. One is the large tract of land, another is a small patch of land. Then it has to be merged or consolidated with the last tract of land.
Absolutely.
Okay.
Large part.
Correct. Then the adjoining land will be only on 4 sides.
On 4 sides.
On 4 sides. Now on all the 4 sides, there may be a multiple owner. It does not mean only 4 owners.
No.
There may be a multiple owners.
Multiple owners.
So if there is a multiple owners, if none of them has any other property elsewhere, then they cannot be displaced of their rights.
That is one aspect.
One.
Yes.
Now what you say, I understand. Suppose a person has, say, 10 multiple small tract of land or a large tract of land in a different maujas. Let us see to go that extent, maujas, or different villages, or under the different Gram Panchayat. Then to merge all the properties at one place, he has a choice. He can say that I want in my village where I reside. Provided the land is available.
Absolutely.
True. He can ask for an adjoining village also, so that he need not have to travel much to reach the field. He can opt. So according to you, that provides 3 opportunities, the 3 places you can say.
Maximum.
And suppose in all the 3 places it cannot be, then no settlement can be done.
The statute also provides for that also.
What?
That suppose.
Take away the property.
No.
Then-
So there the question of option that is while making a consolidation scheme allowed under section 18.
Then the auction is to be conducted.
No, not option. Option.
Option.
Miller. Option.
What option?
Option there under the statute, he can exercise his option where he will take the land. Even
So
the
that
small
you already said three places he can suggest.
maximum million.
That's all.
Likewise, all landowner, not alone land.
So where is the difficulty? If suppose they
What
wanted,
I intend to convey to your
Yes.
Miller
yes,
that for shifting of land or under the statutes, even for a process is provided to adjudicate the right title. And whatever the officer under the special statute decides, it also operates as res judicata because they have been entrusted with the power to adjudicate the right title. Even our honorable full bench of this honorable court also held so. So the question is, Miller, so under the act, the special the officers under the special statute are entrusted with the jurisdiction to decide the right.
no, I understand what you wanted to say, that when the special statute has been enacted, conferring power upon a particular authority to adjudicate upon, the moment the adjudication has come, by virtue of a legislative fiat in making certain changes in the subordinate legislation, you cannot reopen the settlement already under. Sir, what do you think? I understood, but I was just trying to understand because there are certain powers, because I come from a state where the power is given for a revision at any point of time within 60 years. Suo moto. So I was just trying to figure out that whether any provision of such nature is there. So it does not attain a finality in that sense if it is within the mischief period of 60 years. First was a draft list of the publication record of rights, then the final publication of the record of rights.
Right.
Once it is finally published,
Yes.
record of rights, then there is a very little chance of its correction to be made. I do not know what has happened, but there were many options. The exercise was done.
Yeah.
We call it a bhujarot. Bhujarot.
Here is also
Was there. That is what standing or keeping a particular tent at the settlement officer or so, the power of the authority is already there or not. You are apprehending that once it is settled by a officer, finally published record of rights, then in that event it is only that officer who can do it. The third party, he cannot reopen the past transaction which has already been adjudicated by the conciliation. I understand. That is what you want.
That is why I have said, Miller.
Let them come with this. What are you doing? What is your stand? If it is a finally published and there is no power to reopen it, I think only exception is the degree of the court. It should be.
It is also under Rule 34.
It is the only exception is the degree of the court. If the civil court has declared no, he is the owner, then in that event, the settlement will not have any effect.
Right.
So how can you take away all these transactions which were there and which has reached to a finality? How can you reopen those closed chapter?
So we need to file an affidavit.
The difficulty is that means if the consolidated officer or settlement officer who has already adjudicated on the basis of they say certain deeds or certain documents, you cannot go and say that this document is illegal, this document is inoperative, this document is invalid, and therefore nothing could pass. Their apprehension is this.
Not only that, Miller, they are also making this adjudication as null and void.
What is the effect if the adjudication is to be made and declaration that it is a invalid one?
Miller.
That means it is null and void.
Yes, Miller. That means again
Not void ab initio, but it is null and void. So that is what is the effect. That's why I am asking. Yes.
You file an affidavit and whether advocate will also appear in this matter.
Affidavit 1 week after, rejoinder 1 week thereafter. It's an interesting point. I will hear.
It requires certification, because of these rules. Now even those matters are in revision under section 37 or 15.
I have to deeply go into all the provisions. Don't worry about it. Because there is only one act. There are 3 acts in the West Bengal.
Here we also said.
One was State Acquisition, West Bengal State Acquisition Act of 1948, which we call the Jamindari Abolition Act in very common parlance, where any land which was there stood vested to the state, except an option is given that you can exercise an option of retention. And there was a ceiling limit which was put in. Which was succeeded by a Land Reforms Act, which is a very, very exhaustive act. We don't have this Consolidation Act or a Settlement Act of this nature. Is a composite Land Reforms Act which contains all such provisions. Revision of record of right, preparation of the record of right, finally published record of rights, how the publication is to be made, how settlement is to be made. Everything is there in one. It does not go beyond that. And there the power of the civil court has also been taken away. That even a civil court is denuded of power to declare any proceeding taken under that provision to be bad. That's why I think we consider.
Item number 6.
I also say what I heard. Let them come with also reply to that.
I will show them that what they have standards. We'll consider. We will also deeply go into this aspect.
I'm not sure.
Yes.
Item 6.
On behalf of the CORAM submitting here the challenging the posting of the OS officer to his own district and in his own block manner. Earlier approached this honorable court and thereafter recommendation has been filed. That's what till date they have not taken any action measures. In view of the next 2, the notification in page 18, my lord, the OS officer should not be posted to his own
In hometown.
It is in his own block.
Is there in every service. It should be avoided.
Yes.
So why you are doing it? In some of these service bureau students, I have seen in some that at the fag end, they can be posted in the hometown. If they are going to retire within a period of 6 months or a month.
Earlier also it has been objected in 2018.
That was a lot. That is a very good thing because he will retire there. His pension would also be attached to an account within his hometown. So it will be easy to have the pension papers and that's why it is there that 6 months or so. Otherwise, no. What are you doing? What take instruction?
If that's been done, how much of service is left, your lordship? If there is any special consideration for what, why he won't.
There cannot be special. It is not there.
The political influence, my lord, in spite of.
Why you are not made him a party? You are the ground prime minister. And how can it be a public interest litigation?
All
you are a third party, it becomes a public interest litigation.
No, we are the local peoples of that aspect.
What is your right about this posting?
Well, he is influenced person and he.
Influencing will not do. You can come up as a mandamus. There is no difficulty.
Right.
But you can't come up as a PIL. PIL means overall the entire state has to be guided by a certain thing.
Earlier approach under PIL and this honorable court directed to file.
So once illegality, then all times the illegality has to be done.
I have filed the WPC, but PIL.
Why?
Format.
There is nothing. We sometimes close our eyes because of the interest of the bar. Otherwise, if we go strictly, not a single PIL is entertainable. Except you. Take instructions and give it.
I am filing today that.
Item number 7.
May it please my lords, my lord. My lord, would it please the lordships, my lord, most unfortunate matter, my lord, that we are bringing my lord's kind attention. My lord, those documents are now part of your lordship's record here, my lord. Everybody has an Aadhaar card, everybody has a voter ID, everybody has a
Any
PAN card.
preceding, sorry, any preceding documents except their documents,
Sorry, my lord.
any antecedents document?
My lord, I'll tell your lordship straight away. They, my lord, the police Murshidabad has in fact, my lord, and the Panchayat Samiti there, my lord, has confirmed that these are, my lord, bona fide residents originally of Murshidabad who have now, my
Have
lord,
they
come to
disclosed the
do trade and
father, that
business.
the father is also born in that district? Have they disclosed anything?
Lord, I don't know why I'm losing your lordship's connection. Am I audible, visible to my lords, my lord?
Yes, yes, you are both audible and visible,
Lord,
sir.
am I audible, visible to your lordship?
Yes, yes, both, sir.
I'm sorry,
Very
my lord.
much.
Very well. My lord, as far as their fathers are concerned, my lord, because these are, my lord, that issue has not been raised by anybody so far, my lord. But the police as well as the Panchayat Samiti has confirmed, my lord, that these are bona fide, my lord, people who were originally, my lord, from those areas and who have now been for the last 15, 17 years, been staying in Nayagarh district and in and around Orissa, my lord. My lord, the point of law that I am requesting your lordship to consider is this, my lord. These are, my lord, your lordship will kindly see there's a serious constitutional issue here that, my lord, your lordships may need to examine, my lord. The identification, detection, and deportation of foreigners, my lord, is contemplated under the law as an, my lord, institutional, administrative, and quasi-judicial process. My lord, it can't be some unilateral police determination in any facts and circumstances. It has got to be an institutional process under law. Now, my lord, that law is both the Foreigners Act as well as the Foreigners Order now, which my learned colleagues there will show your lordship. Under the Foreigners Order, there is a particular modality. Now, if so detected, I am assuming against myself on a demurrer, if I am detected to be a foreigner, my lord, under the Foreigners Order of 25, that will come into play. You can't then just, my lord, relocate to some other part of the country. That's not the law. Because, my lord, if I am a foreigner, then I can't just be relocated, my lord, to some other part of the country for that part of the country to, my lord, absorb me. Because your lordship will see, my lord, that if substantive proof is furnished, my lord, regarding my citizenship, which is, my lord, my Aadhaar card, voter ID, my PAN card, my Panchayat declaration, then the burden of proof under Section 16 of the Foreigners Act has been discharged by me. That proof is discharged by me, my lord. Then there the matter should rest. My lord, Panchayat authorities have certified. Where is the question then of, my lord, when institutional authorities certify, my lord? Where is the question of one state police disbelieving another state's police, my lord? Or one state's police disbelieving a Panchayat record of another state, my lord? My lord, the right under Article, my lord, 15 of not to be discriminated on the basis of, my lord, religion, and 19(1) D, E, and G, of having the right to, my lord, move around anywhere and free do business anywhere in the country. These are untrammeled rights, my lord. And you can't now be at the whims and fancies, my lord, of any unilateral. My lord, the reason I'm approaching your lordship with great respect is because, my lord, unless this hammer of the court, my lord, is over these authorities, that's the only deterrence this sort of action,
I
which
think,
is
I think
basically,
under
I'm
the,
sorry to say, sometimes mob action.
Mr. Counsel, under the Foreigners Act, what I see is that
Yes, my lord.
if there is any apprehension on the part of the prosecuting officer that he is not a Indian national but a foreigner, then the
Yes,
reverse presumption lies under Section 9 of the said Act,
Yes,
where
my
a
lord.
person has to discharge the initial onus that he's an Indian national, not a foreign national.
Correct.
So I think that's a matter of proof to be done before the prosecuting officer or in a prosecuting proceedings.
But that's not been done here. No,
This is what they will do it under the Foreigners Act. If there is anything, then
would
that can
your
be done
lordship
there.
just see? Your lordship is absolutely right. There is a whole procedure. Kindly see the order, the foreigner's order, my lord. That sets out the procedure, and your lordship will see at sections 4 in chapter 3, section 4.
You file your response. What is there? You file your response within. You are appearing.
I'm appearing along.
File your response.
My lord,
1 week after.
requesting your lordship,
Rejoinder 1 week thereafter.
my lord,
After the house.
my lord, some interim order would your lordships consider, my lord?
No, in this matter, I believe.
My lord, that
Have an Aadhaar card, my lords, and Aadhaar card is also.
Sir, I do not want to, sitting here, do not want to say anything.
my lord, would your lordship then give us a short date, my lord? Would your lordships consider giving us
You let them file. How soon you can file?
Petitions, your lordship.
So 1 week, immediately fix a date for that.
13th January.
13 January will fix it.
Very well, my lord. I'm grateful to your lordship, my lord.
Yes.
Deeply grateful.
Item number
Item 12 acceptance, sir.
item 12.
Yes.
So, now it's in item number 14, an idea has been filed to withdraw the earlier affidavit which was filed by the permission to file.
How can you?
But there were some factual errors in the affidavit.
And you will have to write down that what is the factual error.
That is explained in the IMIU.
They have to please serve the copy. You want to withdraw the counter?
Earlier counted with the permission to file a fresh counter. I think also ready, my lord. Just some facts.
It is submitted by the learned additional government advocate.
Another pair will file a writ petition. I'm the pretender, Millards. That may be tagged along, Millards.
Whatever, we don't know, we'll tag,
Yes.
mention the matter, we'll do it.
Item 15.
Your lordship, we can talk for instructions. But some lordship would like to give it. We have actually lordship or standing.
What?
Instruction to the work has already started, your lordship. And this proposal had come up in the year 2014.
The
After that-
difficulty is, sir, I am unable to assist you properly or to determine the issue properly because I can't read. Your grievance is this.
Within the next month, I am to also supply the translated copy of the ODI election.
The petitioner is directed to How soon?
My lord, 2 weeks.
2 weeks.
Item number 16.
May I please your lordships? My lords, I may be permitted to appear virtually, my lords.
Yes.
My lord, this is a second round litigation, my lords. So I may be permitted to apprise the background of the case, my lords. The petitioner belonged to a place in Dhenkanal, my lords, and opposite parties are government
You
officials.
wanted the construction and the establishment of a Anganwadi center at plot number 81,
Yes, my lords.
which belonged to you.
Yes, my lords.
This belonged to your village.
Belong to our village, my lords.
Who is the owner of that plot?
That village is the owner, my lords. That was in the name of
Village is the owner. I never come across whether the village can own.
Well,
It comprised in the village, I can understand, but the village is the owner, I do not know, sir.
it's comprised in the village, my lords. What happened, my lord? Just my lords, 1 minute.
But who is the owner of the plot?
That, my lords,
Plot number 81. Who is the owner of plot number 81?
that, my lords, I have to find out, my lords.
You do not know, and how you have come? How can you seek a mandamus to direct anybody's or individual's plot to be taken away or to be taken up for this construction? You'll have to say that whether it belongs to a government land, it belongs to what, everything has to be spelt out.
My lord, that is the reason. Just give me 2 minutes time. Let me explain, my lord, because this is a second round litigation, my lord. So, lords, you may kindly see Annexure 5, my lords, page 18, my lords.
Yes.
That is page 18, my lords, Annexure 5.
Yes. Yes.
Yes, ma'am. My lord, the operative part starts from page 22, my lords, paragraph 6. Your lordship got it? Page 22, paragraph 6.
So that was your statement which you made that the plot number 81 is available. What is that plot? Who owns the plot? How it is recorded in the record of right? One has to understand. You can't say that it should be constructed on anybody's property. Right to property is also a constitutional right, sir. So you have to say that this plot number 81 is free plot, government land, no difficulty. One has to understand.
Well, in this last judgment, my lord, it was given a direction specifically, my lord. Thereafter, I went on giving repentation, my lords. Then finally,
No, I understand, sir, but I do not know the language which is used does not really say that it has to be done. It is only recording your statement. Since the opposite parties have categorically stated that plot number 81 is available for development. What is this? It is a submission.
Yes, ma'am.
But whose plot is this? You have to annex the record of right that it is recorded in the name of a government or something. You have to show.
Yes, my lord. Well, my lord, may I pray one thing? Subject lordship.
Yes.
Let this matter taken up next week, my lords. I'll get back to you.
Whose plot is this? Have you verified?
There is actually what I have gathered information is there is dispute between two villages because of which this project.
I do not know, but plot number 81, when there is already a direction,
Yes, ma'am.
then I'll have to show what is this plot.
Yes. I'll bring all that.
Next week, both of you take care of that.
Yes, ma'am. Oblige, my lords.
Item number 17.
November 2020.
Yes.
Oh, this was the restricted hours and so what?
Fine, affidavit, the decision has already been taken, my lords. Where is that building will be function as a satellite center of the DHS, my lords. And
Means?
what are the satellite center of the district health center, my lords? Para 4, my lords.
What is this meaning of the satellite center?
It is also, my lord, if I may refer to the annexure, my lord. Page
7.
7 and 8, my lord. And it's page number 10 gives what all services are to be.
So that too now on a very staggered manner, not on a fixed date means it may not be a regular date.
That is the reason one ambulance is stationed at the old building and the new building is 6 kilometers away from the old building, so that any emergency case can be immediately shifted to the new building, madam. That is also there, madam.
I do not find.
Para 7 at page number 3, madam. Para 7, page number 3.
Yes.
We take instruction. This things are, we can do.
These are, they have done it. They have done at a 6 kilometer, they have placed an ambulance throughout 24/7 there. In case of emergencies, you will be shifted to there. And on a particular date, you will be given a necessary, the treatment.
The more steps are being taken for more services to be included in the old building, madam.
Thing on record, whether the doctors will be available.
It is there. It says that one doctor, they have said one doctor, says one number of doctor, one nursing officer, one lab technicians, one pharmacy officer.
At present, one doctor is there. Public health.
That is, they have said that they have been shifted. You will not, what you say, they have come with the record on affidavit that these are the persons who are there.
We are also not disputing that.
So,
a public health center is functioning right now with the availability of one doctor from 8 p.m. to 12 p.m. and 4 p.m. to 6 p.m.
yes.
That is there in our amendments also.
So sir, he is there. In case of an emergency, he will be immediately called in service. And that's why the nursing lab technicians, everything is there. And there is a nearby hospital which is fully functional.
Is a new district headquarters hospital.
That is fully functional. So that is what is given.
Is that?
We sir. Then in every state, in every nook and corner of the state, then everything has to be done. But these are even in an urban area, you do not get in the close proximity. It is always 2-3 kilometer, 4 kilometer away. Hospitals.
There are community health centers, close proximity and empty.
So they have said that the old building, which is absolutely nearer to you, they have given all the facilities, even one doctor is there, whatever is the reason. And then say emergency ambulance is also provided with all these kind of facilities to shift any patient. It's only in case of an emergency, sir. Otherwise, the natural, other common, the ailments, that does not require an emergent situation. They can be treated.
Physiotherapy.
No, sir.
If we written in their services, written services that yoga part-time, physiotherapy services, wellness initiatives.
Sir, these are all facilities which are given. You can't have it in this way. If there is a nearby hospital which has all the infrastructures available, where is the difficulty? You have filed it today?
Yes, madam.
The affidavit is filed by the respondent.
challenge. Order of the Honorable Civil Judge. Number annexure 12,
Page.
page my lord 57 man. Well, also be kindly turn to page 62.
Supreme Court page 1005. He cannot. He has to argue. See? That is the one. 1005.
Okay.
The award of the year was 2008. Already executed. Sale certificate issued in my favor. Thereafter, after lapse of 17 years, liberty is granted to file appeal.
Oh, that is what I am thinking. And that too, not to insist for delay. What to do? Who is for the other side?
Notice and
notice issue.
kindly stay the operation of the order.
No difficulty. They will go for appeal. We will take care of that when the matter is returnable. If the order is quashed, the appeal will also go. Don't worry.
Notice will come to me in the appeal. I have to appear before the.
No, if it comes to you, then you come. We'll stay. For the other side, who was a writ petitioner? This is.
Is a corporation owned by the state government.
Party number 4, my dear.
Who is representing this?
We are appearing in the writ petition also. We have already filed appeal.
Where is the provision for an appeal?
109. Within 60 days, it has to be filed over. And they are also agreeing to pay the amount.
But madam, what you have done, only single appeal.
Then another appeal I have also filed.
Where?
That is WA number 1912 of 20,000.
Is listed? Why? Why it is not listed? Only pointed, can it be done?
My lord.
Can it be done? Tell me. If there is a period of limitation provided for an appeal, can a court say that don't insist for a delay? And that too after such a long time.
That your lordship, we wanted it to be disposed of on merit. But honorable court said since it is an appealable order, go in appeal.
My lord, one thing.
That is how we have entered that 30 days window.
Kindly hear me. On that day, my brother was in the ICU. On the health issue, time was short for.
So nobody, I was present. Anyway, that is another matter.
We are not, only we are concerned with that. There are, I am aware of 2 judgments in this regard of the Supreme Court. How can the courts say that don't insist for a delay?
We'll come back to your lordship. Since we have already filed the order, my lord agreed.
Then we'll have to stay the further proceedings of this appeal. Now, two writ petitions.
May
One,
I pray, lordship, to take it next week?
when is the next date fixed for appeal?
Next date is on February, not in this year.
Not in this. Next, come in the next week with, it is pointed out. Come satisfy me on that.
We wanted the honorable secretaries to dispose it of merit.
So then we will.
The amount that she is claiming, her client is
Correct,
claiming, is
correct.
not due as
So
yet.
we'll direct the court to decide on that
That
matter.
your lordship will do, but in the meantime, I expect that her to serve me copies.
Yes, it was.
Serve the copy.
Item 22.
My friends are saying,
I am not saying, you are saying. For the match, my lord.
they are very interested. They have got tickets and passes and all that.
No, we have not.
They are privileged.
I
am not got the same
like the
pass
other
as
side,
others.
like the other side, man.
No,
No, that is something. They are saying, why all these? Because we have to wait in line, unlike your lordships.
no.
If your lordship goes at 7 o'clock, also gets to be open.
No.
That is something maybe considered better education. From the
It's a covered issue, your lord. Last occasion, Mr. Mahan was arguing the case. I was respondent number 4. The issue was whether the +3 with Hindi, when you are 45% marks, the equivalent Shastric course or not.
My brother has an occasion to argue. He asked for a time, does not want to take the responsibility. Next week on the prayer of record your name.
Item 23.
Twenty-four and 26, your lordship. So thus, AGH to argue, your lordship. The emergency personal problems, your lordship, in the last moment, time has been allotted to me. He is on leave today, your lordship.
Why don't you serve the copy?
Have a copy.
On the ground of Mr. Shashwat. Full stop. In the meantime, the copy.
Four,
Huh?
26, your lordship.
Who is appearing in 24?
24.
I have for the respondent number 1.
He has to serve copy.
We have said in the meantime we'll serve the copy.
Yes.
And 26, who is appearing? You are appearing, 26?
26.
26 we are appearing, but intervened.
Yes. Copy served?
Copy in something, no, copy has been served on us.
Please serve the copy in the meantime. So all next Tuesday, 25th, 25?
25.
Yes.
My lords, I appear for IOCL on behalf of
Yes, you are appearing for?
My lords, I'm
Pardon,
appearing
you are
on
a-
behalf of Mr. Sunil J. Matthews for IOCL.
Oh, you are for the respondent. Okay, what do you say?
Yes, my lords, IOCL. My lords, Mr. Sunil J. Matthews is in a personal difficulty today. If my lords could have it next week on Tuesday, he would be appearing in court himself.
What is her name?
Sunil J. Matthews.
It's Ashtami Khatri. My name is Ashtami Khatri, appearing on behalf of Sunil.
Next week. An accommodation is sought on behalf of the arguing counsel. Record the name. Record her name. What is your name?
Ashtami Khatri, my lords.
Ashtami Khatri. This is the matter answer. Please, item number is posed today.
Item 27.
Objection to the amendment I am finding. Given the.
Why excuse?
Because within that time I should have.
Belated.
Not related, but within. Right.
Is filing a counter objection.
Objection to my amendment.
Correct. Why?
The Lordship also directed after.
The last provision to. Proposed amendment. This is the PIL. And this was noticed by your lordship. Certain changes, developments have been made. Change the nature and character of the pleadings in
Oh, they wanted an objection that your entire allegation or your entire concern is on the execution case. Since the execution, the decree has affirmed up to the second stage, and the execution has also been levied and discharged on full satisfaction, then this matter cannot be reopened through a different.
They are also not parties anywhere in the suit or in the proceeding.
Well, it is the objection here. It is his objection. My colleagues have objection.
Now, what was the suit for?
Well, this is the, well, this.
What was the suit for? I just wanted
Well, a
to.
suit filed by the Cuttack Municipal Corporation for eviction and demolition of the encroachment, which has been encroached by the private opposite parties.
Suit was filed by
Suit filed the Cuttack Municipal Corporation.
Cuttack Municipal Corporation in the civil court
Before the
for eviction of the
illegal encroachment
encroachment and demolition
made over the public.
and demolition of the structure.
It's fine.
Correct. The suit was decreed,
Suit was dismissed.
dismissed. First appellate court
First appellate court passed the
reversed the decree. Reverse the decree
Yes.
of dismissal means the suit was decreed.
Then the suit, first appellate court
Decreed the suit. Then second appellate court dismissed the second appellate court.
Second appellate court confirmed.
Dismissed the second appeal.
Second appellate court confirmed the first appellate court.
That means the dismissal of the second appeal, sir.
Yes.
Sir, you are before a civil judge.
SLP is also.
Then any special petition was filed.
Yes. Special petition was filed.
Dismissed at the admission stage.
At the stage of-
So the fact which comes is that the suit filed by the Cuttack Municipal Corporation for removal of the encroachment and demolition of the structure is affirmed.
Yes.
Then the execution case was filed.
And one sentence which I may add, in all these proceedings, this encroacher gave an undertaking before the court that on the event he shall launch the entire case, he shall
she shall not claim any input. In all
No, that is what is there because the illegal encroachment and the construction, so no equity in the form of a compensation for demolition. Anyhow, I understand.
affected the whole job.
Whatever, it's not, no equity will come into play. Now, the question is that once the execution case was levied, means for removal of the encroachers and demolition. That was secured by the executing court. And the execution case was discharged with satisfaction. That means the encroachment has been removed.
No.
Then how the court has recorded the satisfaction?
Yes, right.
Now, second question. If you say that it was not executed and the discharge by recording a satisfaction is wrong, then you have a remedy somewhere else why the public interest litigation will file.
In all these proceedings, Your Lordship, we are not the party. We are not the parties.
Because you were not an encroacher.
In the execution proceeding.
You are not an encroacher.
I am not the encroacher, Your
So-
Lordship. I am not
so-
a party, Your Lordship.
No, definitely.
I have earlier also filed a PIL, wherein this Honorable Court has directed to expedite the execution proceeding. Thereafter, I filed the PIL for demolition of the illegal construction, which has been constructed in a public land, Your Lord.
Sir, this concern a subject matter of a decretal property. This PIL is raising an issue in relation to a decretal property. Decretal property means the property which they have defined or given in the schedule of the plaint.
Schedule of the plant, Your Lordship, is a public land. And decree has not been satisfied, and I'm just.
Sir, again, that's why I'm coming. Probably I'm not able to establish a wavelength of our mind. In a civil proceedings, now I'm going in a very academic. In a civil proceeding, whenever a suit is filed concerning the removal of the trespasser, let us treat it as an encroacher. They are the trespassers. Then it must define the land or area which, according to the plaintiff, is encroached or trespassed by the defendants. So there will be a land description in the schedule. Not difficult. Once the decree is passed, that means the removal of a person who is in occupation of the decretal land. True. Now, I am asking, when a decree has affirmed, now whether this relates to that decretal property over which the eviction or a removal order, a decree has been passed. If can you come forward and file a PIL assailing the order passed by the executive that decree was not fully satisfied? Can a PIL lie?
This is one of the prayer, Your Lordship, but our main intention in first inspection we are praying for demolition of the illegal construction.
Sir, that was also a decree passed therein.
Decree passed therein.
So if a decree stood satisfied, then only available remedy is to challenge that order recording the satisfaction of the decree.
That is my humble submission, Your Lordship. Has been perpetrated in.
Then also in a collateral proceeding, you can go and challenge.
And Your Lordship,
You can challenge either. Then again, I am assuming the advisory jurisdiction. What for section 47 of the CPC is introduced?
Final 47 application was filed.
Execution, discharge, and satisfaction. These are the three elements of section 47. It relates to an executability of the decree. Then in that event, what to do?
47
filed by whom?
Application was filed by the encroacher which was dismissed. It has been
still
cannot be executed. Which has been confirmed by the
But you are a third party, sir. You should know your right. I'm purely talking in a civil sense, sir. I am not going into the constitutional.
And also, I am actually unrelated to that proceeding. We all are the
A third party to a suit, how far he can go and assail the order of the civil court? Tell me. I want the law to be discussed in this regard.
Well, this is drain, public drain, it has been encroached upon.
Sir, I understand, sir, the public drain is on a public property. Sir, your grievance is not that because now the encroachment has been removed.
No, my lord, no.
Decree is executed and recorded full. The decree execution case is discharged with full satisfaction.
I have no
Discharged with a full satisfaction. Then what more?
Make the order, you not try, that's the order, you not ship my proper. I number 14614 for your lordship.
Yes.
Annex the order of the executing court.
Yes, to us.
It is that place. My lord, flag C, your lordship, just a minute, flag C.
Yes, I am looking at.
Flag C at the page 7.
Yes.
Page 7.
I can't read that, sir.
No, page 7, your lordship.
Page 7 is this.
No, my lord.
Then
Flag O. I find an affidavit which I can mark as flag C.
this is flag C, sir. I am looking at it. It's an affidavit of 2 pages.
Order taken, your lordship. Newspaper.
That is what is. Sir, this is a flag C.
Well,
I'm looking at 8. Okay. We talked 7, so I was 8. No, that is a government notification.
page 3. Page 3. Page 3.
Page 5 na?
No, page 3 page 3. Page 3, this is the letter written by the London subjects to the Court of Municipal Corporation. Please cooperate with the execution process. Thereafter, on page 5, executive court passes the order on dated 31/7/2025.
So it has been discharged on full satisfaction.
Well, a memo was filed.
Whatever, sir, then under the civil law, if you are aggrieved by an order passed by a civil court, then the PI lies. I am asking you this question. Or your remedy is somewhere else. You can go there.
We have not aggrieved anything. You lordship just
Then-
glance over the prayer of my read petition. Prayer of my read petition. Your
Show me.
Just a minute. What is my prayer?
Yes, show me.
Thereafter, this is the development which has been and your lordship.
Yes, show me.
Corporation, without reducing that person, has
Where is your prayer? Your first prayer at page 14, if I come, your prayer is the municipal corporation shall not be directed to demolish the unauthorized construction.
well, yes.
This is then that is a subject matter of decree.
Well,
Second is executing court shall not be directed to proceed with the execution suo moto. I do not know under the civil law.
your lordship.
Under the civil law, order 21 of the Code of Civil Procedure permits suo moto execution.
You got the subsequent development.
I am again saying this is third is proper stay for satisfying the. Then again you are challenging the order passed by the executing court. Nothing more. Now you wanted. Now you want. Let us.
Confining to my first prayer.
What is your first prayer?
My lord, this is the executive court order which has been subsequent development.
Sir, what is the first prayer of the amendment application or main petition? Just tell me. Main petition. What is the first prayer? Please read.
The Court of Municipal Corporation, Appeal number 2, shall not be directed to demolish the unauthorized construction made over the property of the government situated at Khata number 118 under Annex 9 by using of the loan and preference square.
Correct.
And
Again, sir, again I am going back. When a decree was passed by the first appellate court, does that decree not contain the removal of the encroachers and the demolition of the structure Both. Tell me.
My lord is of their order.
Show me the decree.
Fine.
Let us see. First, show me the decree.
Well, first appellate court's decree starts from
29?
29.
Yes.
Before that, you have paragraph 27, page 20.
For recovery of position.
Portion. It has been reflected by the first appellate. What's last period?
Yes.
What the paragraph, page 27 here. Just a minute. Before the year of going to the decree, judgment here, ordering portion. First appellate court. Para 50. Para 12. First year of page 27. Shall I read your lordship that paragraph? In miscase number 293 of 69 filed by the appellant in the court below for the relief of superannuation in the record, an undertaking was given by the respondent that you demolish the home and remove all materials from the suit, and in the event of a success of the appellant, or you will settle that where a person constructed a building or a house by spending a huge amount and the true owner did not object to such construction that did not take in the court of law, during such construction, the true owner thereafter cannot ask the court to give him a decree for delivery of possession, as the law of equity stands in favor of the person who constructed a house.
But come to paragraph 15, sir.
15 years. Hence, the appeal is allowed and the judgment and decree passed by the law and court will are hereby set aside. The suit of the plaintiff is decreed. The defendant responding hereby directed to deliver vacant possession of the disputed land by removing the construction thereof within the 3 months, hence failing with the appellant their liberty to take the recovery of property.
True. So it contains both kind of a things. Suppose that means delivery, once they are removed, the structure would vest upon the decree holder. And they will not be entitled to claim any kind of a compensation against that structure. That is a very plain and simple decree which is passed. They have removed them.
They have not removed them.
But then you are challenging this order at page 5 of your amendment application. You are saying that this order is wrong.
Thereafter, your lordship.
I am again, sir. Please, then what is the effect of this order at page 5? Order dated 31st July 2025. Please read the order dated 31st July.
Well, answer. On 31st July 2005, this honorable court has issued the notice in this respect. And on the same day, it has been dropped without any vacant possession of the land.
Sir, what are you talking about? Sir, learned counsel for that decree files a memo stating that the CMC has received possession of the decretal property from the judgment debtors.
This is the law.
The memo dated today are put up on calls. Counsel is present and submit that he has received the vacant possession of the decretal property from the judgment debtor on mutual arrangement and prayed the court to drop the execution proceeding on full satisfaction. Peruse the memos and same are accepted. Accordingly, the execution case is dropped in full satisfaction of a decree. One memo is filed. This is what is there. No order is filed. Memo not accepted. That's all.
Right. But this order, your lordship, with the CMC has filed, this is the fraud, your lordship. They have not.
Then also you can challenge this order. You have to challenge this order on the ground of fraud. I am conscious that the fraud unravels everything. It can be taken even in a collateral proceeding. It can be taken at any point of time. Please do challenge the order, but whether the PIL challenging a particular recording of the facts or disposing of a proceeding can be maintained. That's the first question I am asking. PIL is so vast that you can bypass the civil procedural law, you can bypass the civil law, and then the PIL. I am asking you a very simple question in this.
After that, your lordship, I wanted two
No,
certain
sir.
paragraph.
I have given you an opportunity. Sorry, we can't.
One time satisfy your.
I would be happy if you can prove me absolutely wrong. I will be the happiest person on the earth.
And I'll satisfy your notes on the day. So that the PI is measurable on this.
No. You are challenging an order passed by a competent civil court in a public interest litigation. Show me whether that can be challenged. And public interest litigation can stretch and go that far. No.
One way the
And please find out my judgment over there also.
Lordship, kindly bring on record my objection.
No, sir. There are remedies available to you. There is no doubt about it. As a third party, but public, no, sir. No, sir. No, sir. Under no circumstances. Take it. A point of demo. Presidents. Why?
We had a last.
Why?
You going out to the holidays? Not after vacation, first week of January.
Then after?
Next, first on the top of the list.
When?
On 23rd, top of the list.
23rd, he has some difficulty, he says. Then he is looking for after vacation.
After vacation.
So after vacation when? First week or a second week? Tell me.
Second week, second.
Second week, on Tuesday, which is the day? 13th. 13th. Pass matter.
The objection is on record.
Yes, yes.
The message to the rain has been blocked.
My first one.
But that is
Yes.
single bench matter.
That is a single bench.
Single.
That has been called for by this honorable.
Item 28.
This HARISH rule has been challenged and Lawrence AG has to do it. Today has a problem, request to the urgent.
Is it third occasion perhaps? Fourth occasion. No, every day is let him take his time, Manoj.
Let it come after vacation. I request him.
Satisfied that we are not a party to it.
Because this side is always satisfied as long as some interim protection is made.
Only expedite the counter, my lord, and cap the timing is to grant some kind of an interim arrangement. Not
Rule 16 of the
Odisha
Panchayat Samiti allow the
that read with 19. Read with 19 completely whittles down to 43 feet.
Let it come after vacation. I am requesting you.
But convince him.
If an entry order is passed, they can counsel today itself.
But in fact, one IA is fine in view of the imminent urgency in the matter.
What we were suggesting, subject to what you are decided, what we were suggesting, and my learned speaker, Mr. Parija is also there, my other friends are there. You ought to make some interim arrangement so that it's fair to both sides. Let them have their time, let them be satisfied that they have time to file a counter. And we will also not have some
Time.
now if the entire power is handed to BDO, the entire 243G goes for a toss. Completely obliterated.
Next day the interim application will be taken up. On short argument given, then on that day the interim application.
Some protection till then, madam. 2 lakhs has been made. 2 lakhs has been made.
And we are not requesting for stoppage of any funds or anything, my lords. We are saying only that it should be routed to us. That is all we are saying.
Till the
Let
amendment.
it come next week, my lord. We'll see that council will give it.
May I say something? Let them file the counter in the next 10 days. Your Lordship may call it immediately after hearing. And as your Lordship said in the other case.
Next week, I am keeping this matter next week. Second matter.
Yes.
Yes.
This is first matter is there. No?
Yes, ma'am.
Which one?
There are a number of other matters.
But is on
16th, next Thursday probably.
top. So this will be a second matter.
Next Monday.
Of the government advocate.
Monday, Tuesday. Can we have it on Monday?
Actually, we have this.
As your Lordship pleases. We'll leave it at that.
So that we might give justice to those.
No, we'll leave it at that.
One further prayer, Lordship, may indicate that interim order is likely to be considered. Interim application may be considered.
Item number 29.
Yes. There is a delay of 100 or there is a delay. Have you served? Have you served the copy? You have received the copy.
129 days.
Yes, what is it?
In fact, your lordship, I was working as a contractual driver.
Matter of February.
Salary of 15 months was not paid. It was earlier a break with the council, thereafter it came to us.
This is an application for recognition of DB
and 966 of 2025. It may be detagged, my lord.
No, the parties are same, but the issues are different.
Different.
So the only submission I make,
It is submitted by the council appearing. An order which is under challenge, tell me.
No, not. No, we thought it appropriate.
So,
this is a subject matter. The same with your lordship.
Interim order, but
Interim order was passed by.
But that is not a subject matter of
No.
So what is
It must be the final one. The final judgment is under challenge. We have no objection to that.
He been lawyer and representing. First case,
1852.
what do you say about it? Who is appearing for Pratishtha Engineering Limited?
I have instructions to appeal for this time. I'll file a wakalat. Copy be served.
Record his name, appears and submits, but he has instructions and appears. Tomorrow. By tomorrow? This is the matter of next Tuesday for me.
Item number 31.
No instruction. No instruction. Liberty. Any cause of arrest?
You are taking cause, he is not contacting you, why you are bothering?
Old matter.
We are dismissing, if he comes to you, think of restoring, don't worry. Yes, this is. Next.
Item 32.
Regarding non-filling of vacancy of Odisha Lokayat member of Odisha Local.
Yes, what are you doing? But AG has to reply and all that.
Comes to occasion, so your lordship director law and AG will appear and answer this issue, my lord.
Government advocate, sir, you have same responsibility.
But I have not gone through it and all that.
Go through it, please. And what he is raising a very pertinent issue. Then why not take steps to appoint the local?
AG might have talked to government. What is the outcome?
Have you initiated any proceeding? Have you published inviting another people? So anything has been done from your end? Disclose some steps.
I have no concern, I have no idea about this. I have concerned that might have some development taken place.
Excused on the pair of. Taken up.
My lord, we have also filed 2 other PLs which are pending. 21
says this concerns the Lokayukta.
Lokayukta, yes, my lord.
So we are concerned with Lokayukta now.
Yes, my lord. Our cases may be tagged with this one.
No. I am against the tagging.
Your matter is for
Lokayukta, yes.
Same.
Yes, same.
Lokayukta.
Yes, my lord.
What is the number?
21,586 by 2025. For chairperson and members.
Yes, next.
Item 33.
Next.
Done.
Rashid was is to direct the state government to file further affidavit to Rashid because their own counter in their own counter they have admitted my all allegations, man.
Yes.
So far as allegations regarding purchase of some properties are concerned, that is not available to the officials concerned. Neither have been there any information from the MLAs or the whatever allegations. The final proceeding was drawn up because delinquent person is opposite number 5. She is on contractual basis, your lordship. So it was written to the government, and the government has considered transfer of that interest of a minor that will happen on your part.
The issue which we have made, well, the issue is that the siphoning of government money, which has already been initiated by a state agency, state authority. Collector has came to a conclusion, a finding that some money has been manipulated.
What for? The money was sanctioned for what?
For use of vehicle.
Government
vehicle.
By?
Because the delinquent.
The use of vehicle by whom?
By the DCPO. Man.
That is a children, the children, district protection officer.
Child protection.
Child protection officer. So that was taken on rent or higher.
Higher.
Correct.
Manipulation, your lordship, may kindly come to page 22. Man. The finding by the collector, man. The inquiry report filed by the collector. It's page 22.
He says that the payment is made, but this vehicle was not available from February 2025. And this payment was made in respect of what period?
That period has already been mentioned, it has been written that under the above circumstances, just above the table, it is clear that the amount paid by the DCPO against the vehicle such and such as mentioned below for kind reference.
This just relates to
the period,
Period, I think,
from 1/8/2014 to.
No, that was correct because it was there. Then at least the March. Because it was there after February. And then April and then September to next year. The amounts. Oh, madam, this is a serious allegation. If the vehicle was not available from February 2020, payment be made for its utilization.
Your lordship, we have answered in paragraph 7, your lordship, of a counter affidavit, paragraph 7, that it was found that the vehicle bearing registered number OD actually registered in the name of Shri Mitra Prasad Sahu and of Srimati Urmila Sahu. And the said vehicle was converted from commercial to personal use with effect from 2019 onwards, as reviews from the record submitted.
Where from you are ready?
Of our counter affidavit, your lordship. Para 7.
Huh?
By Robin Narayan Sethi, your lordship.
Robin Narayan?
Sethi. of opposite party number 3, Your Lordship.
Paragraph?
7, Your Lordship.
Yes.
So, Your Lordship, on basis of that, the last line, hence the inquiry officer reported that irregularity has been made on engagement of the vehicle violating the government norms. Basing on the report submitted by the inquiring officer, the additional district magistrate CORAM suggested for recovery of hire and toll charges made from 27/4/19 to March 2021, including the excess payment of hire charges.
You have recovered it
Yes, Your
back.
Lordship. And she was transferred, Your Lordship, because she is a contractual employee.
You have recovered it back.
Yes, Your Lordship. All this was done. And Your Lordship, they wrote to the government.
Let them file affidavit with regard
This
to
is
that.
what an affidavit, sir.
Whether they have recovered that.
They have recovered. They have
And
recovered.
Your Lordship, after steps were being taken to drop disciplinary proceedings, and this was intimated to the government also by the ADM. The government said that since that she belongs to the contractual services.
Between you, because we
Yes.
have not done anything. The DP is within you, and you are there to take the decision.
And she was transferred, Your Lordship, from that place.
It has been transferred, but on the very nature of high, it's that she being a corrupt officer by using her position, my lord, she has earned something. Whether they started at DP. But they have started. They started, then they could not provide any proof. They could not provide any proof, and thereafter, they have said that it is, that has been dropped. Well, perhaps it has been misinformed. Your Lordship, may kindly come to page 19 of my petition.
She could not be.
Well, page 19 of my petition, Your Lordship, may kindly come. My read petition. They themselves have came to a conclusion that there is a regularity and necessary action may kindly be taken. But pursuant to that, they have not taken any action, man. That's why I am before Your Lordship. Your Lordship may kindly come to page 19 of my petition, man. Page 19 of my petition for a moment. Page 19 of my read petition, man. The last line will suffice each and every submission of mine. And the very inquiry was on the basis of that commission, man, Women Commission, the authority responsible for look after the affairs of child and women, man. Page 18 and 19. No, in paragraph 13, they have already said.
Yes.
Paragraph 11, the show cause notice was issued. My lord. Yeah, no such record is possible to the successors. The show cause notice was issued. Then they found that a minor penalty may be imposed. And thereafter they say that no further progress has been made. So you'll have to take a step whether minor punishment or legal punishment.
Your Lordship, since she was engaged on a contractual.
Envy of her. He is envy of her. Oh, he or she, your correct question. Envy. So, understand. They themselves are admitting that whatever they say regularity, they have returned it back. Every money was a bit of the money which, according to you, was siphoned, has returned back to them.
Your Lordship,
That is not
since she was.
yes, not. It is not that something. Minor punishment would not have been. That is not the case. It is their own counter, man. That paragraph 13 itself. Yes. But however, as per the records available, the action was not there. Man. It is recorded, I know, but minor punishment. That's all. Page 19, man. Oh, page 19 of my petition for a moment. Page 9. It is serious allegation of corruption of the money meant for the welfare of the child and the women, man. Sir, it is not. Sir, again I'm saying, you are under a misconception. It was not a money allotted for the welfare of the child or for the upliftment of the child. This money was allotted to pay the higher charges for a car to be hired and to be utilized by this DCPO.
There is no allegation which has come out that the DCPO has not discharged his duties. But he has not. Only thing is utilization. Had it been allotted for the food of these children, and this is misuse, it's a serious allegation. It is not. It was not allotted for that purpose. Now they have realized it.
My lord, in fact, my lord, that amount so disbursed, my lord, to that fund was never, that vehicle was never used, my lord.
Oh, that has, they say that has been returned, that has been recovered. Amount has been recovered.
Nowhere it has been, nowhere it has been stated.
We will record the submission which has come out. What more? It is, again, I'm saying a distinction is, had this any amount allotted to these children, because the DCPO takes care of these juvenile homes, the children's, I am conscious. Had it been allotted for these children, and if it is misappropriated, it's a serious offense.
Well, in fact,
but no, it was allotted for utilization of the car. And there is nothing that she has not discharged her duties so far as these children's and homes are concerned.
Well, this is only one facet of that particular allegation to which
that means once you come, then everything will be.
I have annexed.
Why you have got so much? No.
Lord, I have annexed everything, man. Even if
the difficulty that now these people are, because if the court entertains, if they are removed, can you visualize who is the ultimate sufferer? Not you. You will go with a sense of pride and the satisfaction that you have removed. But if the DCPOs are not there, these children are the worst sufferer. They will not be able to extend any benefits from them. I am more concerned with the children, not with you.
Your Lordship may kindly, the sitting MLA, the local representative also, they have also said that there is something mal. But she has misutilized some fund of some fund.
Sir, it is
used for
they initiated
child
proceeding. They initiated a proceeding. The minor punishment has been imposed. She has been transferred from there.
And purely on a contractual employee.
Disciplinary authority have come to a finding that this is the minor penalty should be imposed. We will not substitute ourselves as an appellate court. We will not substitute ourselves. You know the law very well.
We will let her file.
Nor you can challenge the quantum of penalty unless it is shocking to the conscience of the court.
My Lordship may kindly direct to file an affidavit. On the last occasion also, Your Lordship.
Madam, we are recording that it has been recovered.
Your Lordship, we have, I'll file I'll get an instruction to that effect, Your Lordship, from the officials, a clear instruction.
We wanted the litigation to remain alive.
Next week, Your Lordship.
Definitely, there is something behind it. There is something behind it.
Because
we can appreciate how it has come.
We have annexed all the documents, and since they said that a minor penalty may be imposed, and she was transferred. Yes. And she's a contractual employee. The Odisha Civil Services.
That's not a lie.
Further satisfaction that
he wanted that why you have continuing with the contractual employment, you should immediately terminate the contract. He will be very happy and will go home. He wanted that no contract should be.
But a corrupt public servant is holding a very particular post, my lord.
That is what my concern is. I think both of us, we have a lot of experience in working in that field. For one reason, I was heading the JJC, the Juvenile Justice Committee, there for nearly 14 years. I know what is the role of the DCPO, how they work, what is their duty in the juvenile justice system. That you do not know. If they are not there, these children are the worst sufferer. And my brother is now a member of the JJC here. He knows better. You do not know how they function and what are their role. You know, I mean, if you go to the juvenile, I request every member of the bar to go at least find one day to go to the juvenile homes and just visit. You will find that how unprivileged they are and how talented they are. And how the DCPOs just shaped them. How he mentors those children or she mentors those children. Very important post, I tell you.
It's just that there are two vehicles being applied and actually one was.
That's why I say does not know what is the role. Yes, report the it appears from the counter affidavit filed by the state council. State.
As a result, which customer shall come in, there is traffic loss. So to take care of that, that is what this has been filed, man.
I have entered into appearance with the help of opposite part number 2.
Who is he?
For BMC, but for BDA, I was not.
So he is concerned with the traffic jam and the illegal parking.
My lord,
He does not want us to flourish. He is also a businessman. You are also a businessman.
No, my lord.
You are not. You are an
He
advocate.
claims that it is a heritage town. Admittedly, it is a very old town. A town of more than 1,000 years. But both the sides of the now the problem that main problem agitating is that the street vendors who are sitting both sides of the road doing business.
There is a protection which is given. I think the street vendors protection
Yes,
or
ma'am.
removal act is also there.
Yes, ma'am. Because of the street vendors act.
You have to find out the committee. You have to just constitute it and then see it. They can't go and vend all their items in every road. There should be a designated roads for those street vendors. That's some protection has come. Hawking now, at least 20 years before, Supreme Court has said is a fundamental right.
And if my lord will permit me, I can find a regular counter also.
By not counter, find an affidavit disclosing all the scams. And
My lord, I appear for OP3, my lords, for the BDA.
yes, file your counter. Counter means affidavit is a PIL. No question of any counter. It's not an adversarial litigation.
Absolutely.
So affidavit, how soon?
2 weeks time. Maybe
1 week after
after
reissuing, rejoinder 1 week thereafter, and put this matter 2 weeks after. No difference. That's it.
Item 35.
What is this additional document you are buying? Wow.
Not filing additional document. Today I have received the copy of the counter from OP number 4. I'm appearing for BDM my lord. That's it.
How the additional document can be accepted by us? It's filed by you, I believe. These documents. This is filed by you. You are for the petitioner?
Yes, sir.
This is filed by you. These newspaper, these are the things. Not filed.
This is not in my petition.
And who is for the petitioner? He does not know. Showing his signature is there. Whose signature is this, sir? And then turn the pages, these documents.
1514
Yes.
716. Lordship, actually this matter is a transport brief. So therefore, your lordship.
So once you inherit the less asset, you must inherit the liability as well. You know, default. How can this be taken on record without any supporting affidavit? Very casual way of drafting it or filing. You are filing an affidavit today.
No, my lord. Yes, I am for BDM, my lord. I am representing this case, my lord. Of the copy also to the
You must not have replied to those documents because that is not.
Not part of the
that IA is also not been found.
Ruling has not come.
What is this IA?
Your lordship, flag B in IA for stay of the demolition work, your lordship. 7163 at flag B.
Yes.
Your lordship, the petitioners are the resident of Saurashri Bihar. Your lordship seeking direction from this.
Why you want? You are a publicly spirited person.
Yes, your lordship.
If there is a demolition work which is going on, then why? What is the difficulty? Why you are coming and standing in the way of demolition?
Your lordship, they have already demolished. Your lordship. But now the case is that, your lordship, they are constructing that boundary wall for which we have been affected because of that approach road has been closed by the BT. Therefore, we have approached your lordship.
What is required? The copy of the affidavit filed by the
OP4 manner.
OP number 4.
During pendency of this application, lordship may not construct that wall, lordship. Kindly protect me, lordship. Because we are the resident, we are affected by this such construction of that wall.
Unless there will be an inspection to be gone into whether there is already an access you for your interest and egress, nothing more than that. It's not a easement is not a matter of convenience.
Also, kindly have a glance.
There should be some prescription or a necessity.
I have given that map, your lordship. Kindly have a glance.
Maybe then we have to appoint a special officer at your cost to go and see.
And
Alternative road.
You have the access, means of access. If you want, we can appoint a special officer. You will go and find out whether you have a means of access or not.
Lordship, only my request is that during pendency of this application, they may
Sir,
not.
I am, probably you could not, I mean, you understood very well what we want to say. When you can stop any construction of a boundary wall, and that too on a pretext that they are going to the arrest your access to your property.
Yes, sir.
Right?
Not my proposal, Your Lordship, that road, approach road.
Sir, means that your approach road
Yes, sir.
leading to an access to your property.
Yes.
Correct?
Yes.
That means you can't access to your property if they construct.
Yes, sir.
I am appointing a special officer, he will go. And if there is any other access to your property than this, let him come and give a report. Any lawyer you're appointed. If there is other access, no problem. Then we'll have to listen.
We don't take instruction on that IA, Your Lordship.
IA copy not
Otherwise, we
my lord, let the my lord go through my counter affidavit. Then my lord, in counter affidavit, I have specifically said that that construction was already done, and that plot belongs to the GA department, which the GA department has given us on lease. And we have made the construction, and encroachment drive was there. Encroachment drive in the encroachment drive, we have evicted the encroachers and constructed the wall that total area.
Yes.
Item 36.
May please, Your Lordship. Last occasion, Lordship, directed to the State Council to file counter affidavit. But the counter affidavit is not yet filed.
Look, this is matter related to getting job by producing fake certificate. Certificate. I have written 3 letters to the department with the responsible to come to DO Jajpur manner. Today I have to the additional director law of the school and mass institution. Let it come next week, we will file counter.
The prayer of the government advocate. Next thing.
Item 37.
Yeah, please, Your Lordship. My lord, I can see on the eviction of the government land they have improved. Why the eviction?
My lord, this earlier Your Lordship directed, this is the case is pending, that is 7/4/2025 and 6/1/562. These cases have been disposed of by the Honorable Singhil Dutt, and thereafter, my lord, he directed only the collector to take eviction process, my lord. Your Lordship dispose of this matter also in the light of this and under Jagpal Singh versus the state of Punjab. Your Lordship may dispose of the yours.
No, I think there was an interim order in this.
There is no interim. No, I know it. I know it. Already no exposed.
No, there was earlier in the writ petition, which was before a single way. Now it has been disposed of in your favor, so there is no difficulty.
No difficulty. And also Supreme Court has.
Due to such encroachment, widening of the road and the drainage work, it is seriously affected policy.
And recorded no tolerance policy of the government.
Yes, sir.
They have shown no tolerance to the encroachers.
Yes, yes.
Disposed of.
That's my mistake. If you like, man.
And also when the time limit will be given.
A specific time may not be fixed, man.
Call the name.
Item.
Obliged, man.
Right, please, Your Lordship.
Received instructions, my lord. They were supposed to
See,
file affidavit.
both August while they have been directed to file affidavit, man.
We have received the instructions.
And the matter is coming in.
That's true. Sometimes I appreciate their agony when they come and mention the matter. Look at it, sir. In August, there was a direction for affidavit.
Yes,
Now we are in December, and then say now I have received instructions. This.
My lord, give me 1 week's time. I'll file it within 1 week. 1 week.
List this matter, all these matters within a week. Otherwise, they will not.
On the top of the list.
Above our name also. Above our name?
No, man.
Item 39.
My lord, this is PL on Odisha side of the government, and the state government was directed to file a counter appeal.
What? Counter in PIL, not a counter. Only
No,
affidavit.
affidavit, yes.
Yes. Who is for the other side? Shashwat Udras, he is not available today, I'm told. For some personal reason, he is not available today.
So Das is not there today.
Coming the next week, let Ms. Das start. Yes, on the ground of an accommodation. And here I have said, the Das who is being disposed. Matter to appearance of this.
Item 40.
No, it's actually this matter was.
Item 41.
40.
Item 4G.
In 40, I am for this petition, my lord. I have filed this PIL. There is a reason that the
Removal of the, what is that, like the amount allotted for renovation of Lord Ganesh's temple has been utilized.
that was diverted to construction of a illegal gate, my lord, along with 2 lakhs diverted to for construction of a road, my lord.
Why doing?
No, my lord, we have filed a counter, my lord. They have said
My lord,
that.
I filed my rejoinder, my lord. Yesterday only I have received some documents through RTI, my lord. I'll file my rejoinder within 2 weeks.
You want to go ahead rejoinder?
Yes, my lord. I'll
You
bring.
have filed or not?
No, I will file my lord. Yesterday only I have received.
No, not. Whatever.
Sorry. Item 41.
My lord, in this case, I have received the copy of the counter. And the main allegation was that in the PIL matter, there is the Roino jury was going to be, that is a filled up by Morse and parties. Also, they have cited the map, but in the case, in the map, it is purely reflected that they have already, that is obstructed, that is the water thing. But now they are saying that there is in the side of the water thing, there is a road, and this cannot be, it has not been done. So I have to file the rejoinder in that line. So if your lordship put up a
Rejoinder
within 7 days, man.
After 2, which will be sir. It's called the next.
Item 42.
I think. No. 42 must have requested for one amendment to filing of counter. So come for the first time after notice was issued.
Extension of right.
Matter relating to 41. This is the matter relating to construction of one PSP.
Yes, just copy that. Immediately after.
Next month. Item 43.
43 readings are not complete. The railways were supposed to.
Can it be after vacation? Then it will be.
My lord, I appear for the respondent, my lord. My writ petition was allowed, my lord, and in the month of May, and it was, and a stay order was made in the month of May. Now the final appeal is ready for hearing, my lord. The appeal has to be heard.
Who is appearing?
I appear for the writ petitioner respondent, my lord. The writ was against the railways and the opposite party private respondent. The private
date in January. By that time, it will complete.
Well, it's an appeal, final appeal.
Maybe, but it's required time. Let's keep it to after vacation. Appeal hearing is required.
Well,
is our siding?
Second week of January 9th.
Yes, my lord.
9th.
Yes.
Please, my lord.
Under the same heading for final disposal.
Oh,
6
months.
Of that. That's how the client gets going also.
Grateful, man.
In the meantime, it is open to the parties to complete.
Forty-four.
Please, Your Lordship. Your Lordship, I'm appearing in item number 44, Your Lordships. I am for the respondent. No, my Lord, I have filed an IA for vacation of the interim order, my Lord.
Please for the
Your Lordship.
appellant. Yes. I'm for the respondent number 2, man. Yes. This is a matter about, Lord, it relates to a sale under the Surface Act. It relates to sale under Surface Act. Lord, a rice mill was sold. So, Lord, can you see there is a impute judgment. Page 127. Starting from 155 onward. Forty-four months. 46. The bank is the appellant. Who is for the lead prisoner?
I am for the respondent, my Lord. My Lord, may I be allowed to ask?
Can you sustain this order?
Yes, my Lord. I can.
Can you show me how the Himachal, this judgment has any application? Himachal Financial Corporation.
My Lord, that's Haryana Financial Corporation.
They are governed by a different special law.
My Lord.
Tell me that how this judgment applies to a Sarfasi proceedings. As is where is when it was done. How can a court, a writ court, direct the entire things to go?
Exactly, my Lord. My Lord, may I only take your facts just before I go to the...
No, facts are very clear. There was a proceeding under the Sarfasis, 13.2, everything, this notice was given, 13.4, steps taken, after 14 compliance, ultimately Rule 8 of the security enforcement rules, they published it, put an auction, recovery officer put it, you were the bidder. The auction says as is, where is conditions, what is there. You could have inspected the property before you offer your bid. Now, once the sale is confirmed, registration has been done. The bank says that there was only thing is the bank says there is an access land. Subsequently says no access land. I am not going to say this. But anyhow, how can a court set aside this in a writ jurisdiction and then say returned with the commercial writ court?
Yes, Your Lordship.
Show me one judgment.
My Lord, I have satisfied.
Show me a judgment that writ court can go that far.
My lord, we have answered the maintainability as well, my lord. If your lordship has, my lord, para 10 of my counter, we have said that it's fraud. Fraud is the only reason on
Again,
which we
I am
require to
again
maintain.
saying, does it require? What is a fraud?
My lord, if that is why my lord, I said if your lordship give me
No,
indulgence for 2
sir.
minutes, I'll
No,
just type.
sir. No, sir. And there was no discussion on a fraud.
My lord, this is my entire case, my lord. My lord, may kindly see my
There was no
petition.
discussion by the single bench on a fraud.
My
The
lord, may
mere
I-
saying
may I
it
be
is a
allowed,
fraud will not do. Particulars of the fraud has to be pleaded under Order 7, Rule 4 or Rule 2 of the CPC.
I completely bow down, my lord. My lord,
So-
may give me 1 minute. My lord, may give me an indulgence of 1 minute.
I understand, but there is no discussion on the fraud. There is no discussion on the fraud. No case of such nature is made out. We don't know whether the writ petition is founded on a fraud or not.
My lord, it is because that is why the writ court.
But we do not find any remnants.
My lord, that is what I'm
the
endeavoring
fraud.
to show your lordships. There was a Tahsildar was asked to give a report. A report has been filed before the learned single court, my lord, single judge. My lord,
Can
give
a
me a
court,
minute's
writ
time.
court go into such nuances?
My lord, that is what my case is. My lord, may give me a moment's time.
We can't go in this way.
My lord, my case is it is fraud because of a very simple reason. They give a advertisement, my lord.
Where is the writ petition? Show us.
Yes, my lord. My lord, may
Where
kindly
is the
have my
writ
writ petition. It is with your lordship, my lord.
80 and Annexure 2.
No, it's a counter affidavit. Where is the writ petition?
It starts from page 26. Page 20, page 25 below, 24 onwards.
No, my lord, writ has come along with the writ appeal, my lord. That writ petition.
Annexure 1, page 22.
No, I am not. I'm just seeing.
My lord, may kindly have para 4 of my writ petition.
Sir, where is you have said only illegal, arbitrary and void. Now tell me where is the allegation of fraud? Show us.
Yes, my lord, may kindly have para 4 first.
Yes.
My lord, para 4 I state that the petitioner being interested in the aforesaid property mentioned in the
I say
e-auction
after examining the details and the document and sketch map, you proceeded. Then
correct, my lord.
where is the fraudulent act? Tell me.
Yes, my lord. My lord, may kindly see para 6 and 7.
Yes. Show me.
Para 6 is petitioner on 1810 for the purpose of registration and mutation requested the OP number 1
No,
and 2 provide the sketch map.
this sketch map was provided. Then
Yes, my lord. My lord, kindly see 7. That after receiving the aforesaid document, the petitioner took steps to register the sale before the concerned sub-registrar. During the said process, the petitioner learned that the property does not have approach road. The petitioner immediately contacted the bank with the said information. Please see my lord, para 8. Subsequently, on 18-2010, OP number 1 and 2 demarcated the said plot and sent a new modified sketch map to the petitioner through email. The petitioner was shocked to learn that the said auction plots have no ingress or egress access and the bank has taken over the possession. It was done purely on misrepresentation. That's my entire case.
Where is the proclamation? Notice of proclamation.
My lord, may kindly have the emails as well. I have annexed. My lord, may kindly have page. Yes,
No, I understand what you want to say.
My lord, may kindly have page 24 annex 5.
Just 1 minute.
Yes, your lord.
E-auction sale notice.
Page 24 annex 5.
You have already indicated the time of the inspection of the property. So have they not gone for an inspection before the participation?
Yes, they have gone.
We did, my lord.
That is what they say in para 4. And
Yes.
advertise the maps.
Let me kindly have page 24 annex 5. My lord, may I have page 24 annex 5, email dated 19th October, given by Indian Bank at the bottom of the page. My lord sees it says, sir, we are herewith attaching copies of related documents available with us based on which loan was sanctioned and subsequently put on sale under e-auction after the account become NPA. My lord, may kindly see the next page. It attaches a Noxa.
Is this, you show me where I do not find there is any element of fraud which is there, because there was already, it was as is where is basis, there was already a date for submission of, the date was fixed for inspection of the property. Have you inspected the property? Have you taken the care? Everything has been done. How you get an access to the property without any
exactly, my lord. That is precisely my case. That is precisely my case, my lord. My lord, I have
you could not get an access to the property.
No, my lord, I did have access. My lord, may kindly hear me out, my lord.
So then go and use that on the basis of the sale deed. The map is there, sketch map. Is a subsequent.
Give me a moment. My lord, just a moment, my lord. If your lordship may allow me, my lord. They changed the Naksa.
No, actually we are not provided, and whatever, even if they have given it, the plot numbers are same in all the maps.
No, he wanted an access road. A particular plot is a landlocked plot.
It is not landlocked.
That is what is the main concern.
He reverted back in his after he took the sale deed, my lord. Your lordship may kindly see page 31, page 31.
In the sale deed, you have given him a new map.
No. It was subsequently when he asked, then they give.
The same map, same plot. Those plots were not sold. And he has a right of easement that also the other person had, Lord. And he was satisfied. Page 4, your lordship may kindly see page 31 and paragraph 4, which detailed document including sketch map is sold a road, the petitioner.
This can't be said to be a fraudulent one or something like that, which is an apparent. No, we can't. And how can a grid code go into that aspect? And there is nothing needed about the fraud.
Yes,
my lord, may I just give me a moment, my lord, to
show us, huh?
My lord, may only juxtapose just two documents, my lord. I'll not ask for a moment. My lord, may kindly juxtapose.
How the construction came without an access?
My lord, may I? My lord, may only request is, my lord, may kindly juxtapose two documents given by the same bank at page number 26 and 28. 26, they give me a Naksa with a road. 28, they said there is no road. The Honorable High Court asked the Tahsildar report, my lord. Tahsildar report is on record. It says there is no valid approach road to the rice mill.
That is another one, valid or invalid.
I'm sorry.
But how the writ court will go into one aspect?
My lord, it's my case, my lord. My entire money I have given
Sorry,
5
under the
crores, my
surfacing,
lord, on the.
Then there is already a forum which is provided. You can go.
My lord, it's
approach that forum.
My lord, it's a fraud. My lord, sees it's
so whatever, then it is.
My lord, Supreme Court is clear finding. They cannot simply say as is, where is basis by suppressing facts. They have
this
to
is
say
not
what it is.
The only thing is, I do not know subsequently who is correct and who is wrong. We don't know.
My lord, that is why. My lord,
It's a matter of the evidence. And Tahsildar, is this particular report a sacrosanct? Tell me, is an opinion evidence? Does it not require to be corroborated by something more?
My lord, my entire.
How can a report of the Tahsildar be sacrosanct?
My lord, my respectful submission is, my lord, the report of the My lord, may kindly give me a chance.
Have you
my lord,
have you recorded? I think the fraud has not been considered by the single bench.
My lord, may I only give a
Because he
chance
has
to
not
be stated? Sorry, my lord, my lord, may kindly give me a chance to justify, my lord. I'm sorry, my lord, I'm just asking for a chance to justify.
Show us the judgment of the Supreme Court on this. Show us.
May
Line of
kindly see.
judgment.
Yes, my lord, may kindly see the judgment, my lord. The
Show us.
Haryana judgment, my lord.
Show us the judgment. Yes, go. Going and upsetting the entire sale and all, everything is a declaratory degree. Absolutely a different story. You are talking about the Haryana Financial Corporation. They are governed by a different law than this law. They are governed by the State Financial Corporation Act.
My lord, may kindly have the judgment, my lord.
Yes, please.
Yes, your lord. My lord, the Haryana financial judgment, my lord.
Yes.
My lord, may kindly have para 2, my lord, which says the facts, saying shown of unnecessary
There
details.
is no forum provided under that tab. But under the surfacing, the forum is provided to you.
My lord, they have also relied on that, my lord. My lord, may kindly have a look. In fact, they are saying Rule 87A of the Security Interest Enforcement Rule says that every fact has to be declared by the bank. And here they are suppressing that they have no road. They are first showing me that there is a road. Then when I say that
That is what I'm saying, that how far a rate court will go into these aspects when you have an alternative forum where more evidence is required to be adduced. Clearly, your Tehsildar's report.
My lord, my humble submission is there is no evidence required because it's their own admission. My lord, may kindly see 26 and 28 page number, my lord. That's the only thing I'm trying to show, my lord. My lord, there also in para 11 in the judgment.
I do not know whether you agree or not.
My lord, may kindly see, my lord, it's an exact case where the approach road was not there. Honorable Supreme Court said, my lord, may kindly have para 19 of the judgment.
Then it is
May I only place para 11 and 19? May I try and make a case, my lord? Para 11, Mr. Amit Dayal, Learned Counsel for the Appellant Corporation.
Mr. Manthi, have they admitted that they have played fraud?
Yeah. No, my lord, not fraud, but they have given two. My lord, may kindly see. That is what I'm saying. 26 and 28.
That is the case of a forfeiture of the earnest money which was deposited on certain grounds. Then the question was raised in that writ petition entertained that whether their act of forfeiture is justified on the facts of the case. When you have raised that there is no rasta, here the sale deed has been executed.
But it's not been executed. That's a false statement. Please ask them to show. My entire case is the registration is not being allowed because it is a landlocked place. It is a false statement made. There is
Sale
no
deed has
sale
been
deed.
executed.
Please ask them to give a sale deed. I have no case.
Registered.
He did not cooperate for registration.
Oh, he did not. It's only the sale certificate which was issued. That's a confirmation of a title.
My lord may kindly say, if I am not supporting, my lord may kindly say sale deed may be issued. I have no case. I'll go back home. The entire case is sale deed is not being issued by the sub-registrar because it's a landlocked property. That is why I came back to them. And then they said, okay, no, there is no road. You take it or leave it.
Requirement for registration.
It is not. Justice S.B. Sinha's judgment is there of the Supreme Court.
The possession of to have been given.
Lord, my entire thing was I took it on your statement.
Is given then sale certificate.
And I'm not a party before DRT, my lord. They have sold me and then saying that you go to DRT. I've already, my lord, paying money. I've 5 crore rupees I've taken over. My lord, may kindly see the judgment, my lord. Then in para 11, they say, my lord, that the appellant corporation submits that the respondent accepted the plot on as is where is basis. Therefore, the appellant corporation cannot now permit the respondent to wriggle out of its confirmed bid on the ground that there is no independent approach road to the unit. The learned counsel further submitted that it was the respondent to make necessary inquiry with regard to the existence of 3 Karam's Rasta with the revenue and other authorities. Now, my lord, may kindly see para 12. The learned counsel further pointed out that the respondent had visited the site on 21/1/1998. Therefore, he would have known the exact situation of the Rasta. The respondent was aware of the exact nature of the land being purchased by him. Para 13. The learned counsel further submitted that the appellant corporation is entitled to forfeit the security amount in view of the clause 5 of the terms and conditions of the sale of property as contained in the advertisement dated so and so. Now, my lord, may kindly have para 19. This is where they have started holding. A perusal of the aforesaid letter makes it apparent that the appellant corporation was merely relying on documents submitted by Messrs. Unique Oxygen, that is the defaulting unit. The appellant corporation has been informed by the management of the defaulting unit at the time of availing the loan facility. The unit had the necessary independent approach road. Para 22, my lord. This is where the opinion is. We are also of the opinion that the division bench was justified in further concluding that in law, the appellant corporation undoubtedly has the power to forfeit the earnest money provided there was a failure on the part. The division bench, however, observed that the respondent was dealing with an instrumentality of the state. He was entitled to legitimately proceed on the assumption that the appellant, a statutory corporation and instrumentality of the state shall fairly. The respondent could not have suspected that he would be called upon to pay the amount of rupees 50 lakhs without there being given even a proper passage to the unit that he was buying. We are of the considered opinion that the respondent had deposited the sum of rupees 2.5 lakhs on the clear understanding that there would be an independent approach road to the unit. This is understandable. Without any independent passage, the plot of land would be not more than an agricultural plot, not suitable for development as a manufacturing
this is the
unit.
fact, sir. You read the judgment in that.
I bow down to your lordship.
That was a case, very unique feature. There was an access road. The defaulting the unit placed this particular land. The defaulting unit placed the particular land with the financial corporation. The financial corporation found that there is already an access, but later on it appears that this access was through a other plot of land which was purchased by the defaulting company, and the defaulting company did not pledge those lands with the loan. So it was a private land. So they say that once those lands are outside the purview of the hypothecation or a pledge, then in that event the bank manager wrote to the office that there was no Rasta, because this Rasta belonged to something else, is another property. In that, the court has proceeded on the basis, because there is no other remedy which is provided to the defaulting party when the forfeiture occurs, that once you have admitted, you can't retract from that letter 98. That's an admission which has been made, and the court has said that the act of forfeiture is wrong.
My lord.
Here you participated with the open eyes.
My lord, I am drawing a parallel between both the cases.
Sorry,
my lord,
you can't. Show me another, the red court can go to that extent, another judgment.
Your lordship may give me one more date, my lord. My lord may kindly see it's a clear case where first they show me there is a road, then
We'll have to. When you have a remedy, you should not have been done. And declaration
I have no remedy, my lord. My lord may kindly see it's a fraud played on me.
Come ready on the next day. Show me on a court also in a writ how far without an evidence the court can go.
I'll try and satisfy your lordship, my lord. My lord may give me a short date.
When? Next week?
Deeply obliged. Deeply obliged. Gratefully. Deeply.
Don't mind. That is the irony. Whenever the bench, particularly me, put a lot of questions, it always augments the adjournment. Encourages the adjournment.
My lord. We will try our best to satisfy your lordship. Sometimes we would want more preparation, my lord. As it fallen from your lordship, my lord, we will need some time more preparation, my lord. That's just how it is, my lord. But
Yes.
I'm grateful.
Yes. Come ready on that. And you also come ready with this in your SLE.
Grateful.